On August 30, 2016, a Miami-Dade jury awarded Richard Batchelor and his wife more than $21 million after finding that his mesothelioma arose, in part, from asbestos exposure during overhaul work at a Florida power and light company FP+L power plant. On December 27, 2017, the 3rd District Court of Appeal erased the verdict against defendant Bechtel Corporation Bechtel, finding that the jury should never have considered claims against that defendant because of plaintiff's insufficient evidence. The appellate court also found reversible error in an adverse inference instruction, and concluded that Bechtel's efforts to locate discoverable information were reasonable under the circumstances. Between 1974 and 1980, Richard Batchelor worked for FP&L as an electrical technician at 2 power plants, including the Turkey Point power plants. At that time, Turkey Point was a sprawling and complex facility, occupying over 3,000 acres and containing 12 nuclear-fueled units and 2 oil and natural gas-fueled units, and provided power for all of South Florida. On any given day, 400 FP&L employees and numerous contractors worked at Turkey Point. Mr. Batchelor was responsible for repairing and maintaining gauges and equipment at the site, including 4 of the nuclear and gas units. Insulation, an indeterminate amount of which contained asbestos, covered the various pipes, wires, and equipment at the plant. Mr. Batchelor never removed insulation from any equipment and never worked on equipment while the insulation was being removed. Instead, insulation removal was performed by independent contractors who specialized in insulation removal, and other FP&L workers. Mr. Batchelor did work in the vicinity of other workers removing insulation, but it is unclear how close Mr. Batchelor worked to those removing asbestos, how often this occurred, or the duration of the occurrences. When asked by his attorney if the dust he breathed in was from insulation, Mr. Batchelor responded, "It could be from anywhere. It's just dust." One of the contractors retained to provide ongoing maintenance services of the equipment on site was defendant Bechtel. The contracts provided that FP&L would issue work orders at its discretion to Bechtel, which would do the work requested on a cost-plus basis. FP&L decided whether FP&L or Bechtel would provide needed supplies, equipment, and ancillary services. During the relevant time period, Bechtel provided 1,050,070 man-hours of services at Turkey Point. FP&L periodically shut down the units for repair and maintenance. During these shutdowns, FP&L had Bechtel perform major overhauls on the units. FP&L also had another contractor, Foster Wheeler, perform maintenance on the unit's giant boilers, which were lined with insulation. Although other contractors were present most of the time, Bechtel received work instructions only from FP&L. In 2015, Mr. Batchelor was diagnosed with terminal mesothelioma caused by asbestos exposure. On January 2, 2016, he filed suit against 26 defendants, including Bechtel Corporation, for negligently causing his mesothelioma. Mr. Batchelor's medical causation expert never examined Mr. Batchelor and never visited Turkey Point. He based his opinion solely on a review of Mr. Batchelor's deposition and published medical studies. Mr. Batchelor's claim against defendant Bechtel was based on premises liability, and contended that Bechtel was liable for any asbestos exposure he sustained from any source at Turkey Point that was under Bechtel's possession or control. More specifically, Mr. Batchelor alleged that Bechtel was liable for the dangers of asbestos dust created by Bechtel or by others in the areas of Turkey Point that were being controlled by Bechtel while Bechtel performed its work at the time Mr. Batchelor was exposed. In early August 2016, Mr. Batchelor's attorney deposed Bechtel's corporate representatives. Immediately after the depositions, Mr. Batchelor moved for sanctions, arguing that Bechtel failed to adequately search for documents and information from 36 to 42 years ago that might have been provided by retired former employees. In opposition, Bechtel argued that it had no obligation to find former employees from so long ago and that attempts to locate past employees in similar lawsuits had proved futile due to the passage of time. Ultimately, the trial court granted the motion for an adverse inference.